also, I note that some of those cases that you cite that stand for the disallowing of the petitions don't really stand for, I thought, what you were holding them out to. Somebody's petition did, that signature did appear in someone's petition. It appears in those two cases, and one is Coleman and the other is Coleman and the gentleman running for Congress, I think his name began with an H. They were able to, because of they had switched over from hand signatures to digital, they were able to basically establish the order of the signatures, which I don't think we're able to do here.
Correct.
And because they did, they only disqualified it as to the respondent.
Right.
So somebody's petition got the benefit of that signature, correct?
I don't think that that's the case, Judge. In those situations, I believe it was that an individual signed the same petition twice, both digitally and physically, and they eliminated one of those two. But when in each of those cases, and in every other case, there are many Office of Administrative Law cases, the standard is that if someone signs, if an individual endorses petitions of two different candidates, that both of those would be deemed invalid, and the one being challenged would be invalidated.
Well, I guess the other gentleman was Fizz Herbert, and the conclusion is
that those 16 signatures were all disqualified, Your Honor.
those 13 signatures are counted as valid. Okay, let me just see. But if, and again, the 16 signatures are by persons who signed a nominating petition for multiple candidates for the 2nd Congressional District. Accordingly, with respect to Fitzherbert's nominating petition, his and his alone, their signatures are invalid. It doesn't say they're universally and globally invalidated.
So, Your Honor, I think the distinction there is that the only petitions being challenged were Mr. Fitzherbert's. Right? This is one of the arguments that the clerk makes. The clerk makes the argument of, well, we would have to go and check everybody's, and that's not the obligation here. Every petition, as a matter of law, is given a presumption of validity, right? And that is baked directly into the statute, and there's case law that supports that proposition. When a petition is where this issue comes up, so it's not the obligation at that point, and those challenges are filed, by the challenge deadline, right? Now, in this situation, for example, Judge, if we had filed a challenge with the clerk and said, here are all the duplicates, we didn't have the documents, but let's assume, for purposes of my hypothetical, that we had filed a challenge, 2 or 3 days before the challenge deadline and said there's all these duplicates. And then Mr. Mendez came in, or another candidate came in, or another individual from the city came in and said, oh, well, we also want to challenge, Mr. Gau's petitions or Mr. Saya's petitions on duplicates. Then both of those challenges would move forward in parallel. And any duplicate signatures on either of those petition packets would be invalidated because of the law. It's not, there's nothing here about temporal filing deadlines. That concept does not appear anywhere at all. And the only temporal issue.
In the other case that you cited, and let me give you the name and let me give you the language, and that's what I drew from it. It's what is it, singing? It's where they have the digital nominating to the hand signed one.
I think Onuha.
Yeah.
Onuha.
Christian Anuoha and Sammy Gindi. Again, it says, again, there are multiple reasons why they're, but signer of multiple petitions. Gindi challenged 2 digital signature forms which were noted to have been submitted in support of Anuoha by individuals who also signed Gindi's petitions on the written signature sheets. And it gives the names. It says the singer who signed petitions for different candidates for the same office is disqualified from signing the nominated petition. And then it goes second, but it says upon the conclusion that once the digital signatures form become available, candidates were no longer permitted to obtain signatures by written signature sheet. Follows that Alonso and Snedeker must have signed Indy's written signature before submitting digital signature forms on behalf of Onawaha. So I find that these signatures must be stricken from Onawaha's petition. Doesn't say they're stricken from Gindy's petition, who we signed first.
Understood, Judge. But again, so there's two issues there. One is that case relates to during the pandemic, an executive order that allowed for digital petition signatures. There was timestamps. There was all kinds of other things. But again, the challenge there, it was a challenge. It was, if I remember correctly, it was a challenge from Onawaha to Gindy, and then a cross challenge, essentially. And so
But they didn't strike it from one of the challenges. And your position is the nuclear one, which is they all are invalidated. That doesn't seem to hold for that proposition at all.
No, Judge, they're invalidated as to Mr. Mendez's petitions because that is the petition packet that has been challenged. There's no obligation here for anybody to go back through all of the petitions that were filed for all the other candidates. And
well, but I mean, a broader reading states that the petition, the signature does wind up meaning something for one petition. And the way the clerk did it, these signatures are only on one petition because she's excluded those that were subsequently filed.
But Judge, so the fatal flaw here with the clerk, so number one, there is no law at all, and they've not cited any because it doesn't exist in this state.
Well, that's why I guess she's granted a lot of discretion, which we don't have to disturb if we find it to be reasonable.
But so Judge, what that is saying is that if myself and Mr. Mensch are both running for mayor in Patterson, and we arrive at the clerk's office at the same time, and he happens to sprint up the stairs faster than me to file his petitions, then he gets the benefit of that and I don't. What the clerk is trying to do is say that, well, because Mr. Mendez filed his petitions first with her, that must mean that the signatories signed the petition for Mr. Mendez first. There is no evidence of that.
I agree with that, but I do believe that, I think it was Mr. Gordon or maybe Mr. Mensch wrote, in order for her to determine if subsequent petitions are going to have the same person's signature who signed the original one, that means she can't certify these until the last petition is filed. And that would be untenable. That would be unworkable.
I respectfully disagree, Your Honor. I think that, again, I think the clerk's process here is not one that anybody else, that the Secretary of State, the Division of Elections follows. These petitions have a presumption of validity. It's clear here that the clerk has checked them, and the clerk has admitted in the papers that are filed with us.
When she checked them, there was only that one to check, though.